Good morning and welcome. It is Sunday, January 25th, 2026, and this is Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Hello, everybody. I'm so glad that you're here. I know that we switched it up on you a little bit. It's an hour earlier, but we wanted to make sure that you had plenty of time for all of your football festivities today. And I hope you're staying warm. True crime in a minute, Legal Cat, Chi-Town, Farm Girl, Afton, Kathy Mama Bear. It is a cold one today. I checked in with Kaylin, our Courtroom Confidential meteorologist. She told me that it is -5 where she's at, with a wind chill of who the heck cares, because at -5, you don't even try to feel, you don't even care what it feels like. You don't go outside. So I hope wherever you're at, you're staying warm. I understand too that this is like the big, or maybe it's already been snowing a bunch, but I thought today was supposed to be the big snow day. I think the storm is getting toward the East Coast, but in any case, you know what helps you stay warm is when you're super juiced. So I hope you guys are. We are. Today's going to be a very good show. We're very excited about it. You had a lot of really great questions. Again, every single week, I know I say this, I don't want to sound like a broken record, but every single week, you guys amaze me with the questions. And they're always stuff like, God, I had never thought about that. I've been doing this for a very long time, lawyering. And you guys come up with questions that I never thought about. Some of it's stuff I take for granted. Some of it's stuff I just never even gave any thought to, but they're all fantastic questions. So thank you, everybody who asked questions. We had a lot. So I wasn't able to get to everyone's question, but I got to every topic at least. If I didn't answer your question today, don't get mad at me. Don't throw tomatoes. Don't leave us and never come back. I promise I will do my best to spread the love and get to your question next time. Come back again. It's just, we can't get to all of them. And so I tried to make sure that we at least answer your question, even if I'm answering it through somebody else. So good luck to all the Pats and Broncos fans today. Good luck to all the Seahawks fans today. But mostly Godspeed to all the Rams fans today. Deborah Guzman has been a member for 11 months, everybody. Golf clap for Deborah. Good morning, everyone, she says. Good morning right back at you. Freckle Feet Kitties says, yay, Sunday, snowy, fun day. Well, we hope that you are staying warm. If this is your first time here, welcome. I think you're really going to enjoy it. Let me introduce myself and then tell you what this show is about. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for over 10 years before I left to go into private practice as a criminal defense attorney. And we started this channel, Courtroom Confidential, with the idea of presenting to you both sides of the courtroom. And we hope that we do that. And then we started this show, which has now become our favorite, and it sounds like the favorite of a lot of you folks as well, called Sunday Fun Day, where we take your messages that you've left us throughout the week, your voice messages, and we answer them live here today. So I think you're really going to enjoy it, especially if this is your first time here. Arizona Gal, thank you so much for kicking us off with a super chat. Says, hi, CC fam. Logging for the first 30 minutes. I have a full day of counseling clients. Thrilled to be here. Love you all. All right. I'll try to get all the good stuff in the first 30 minutes so you don't miss out, Arizona Gal. Well, then I'm glad we started a little bit early for you too. Stay to the end. As always, we do have some announcements about some fun stuff coming up that I don't want you to miss out on. So please make sure that you stick around. But take a deep breath. You've made it to another Sunday. Hit the like button if you haven't already. Subscribe if you're new here and you haven't already. And share this with anybody that you might, you think might enjoy this. But you guys came through. Let's go ahead and see who kicks us off this morning.
Hi, Josh and the Sunday Confidentials. This is Lizzie from Almost London. Hopefully talking a bit louder this week. So question regarding the au pair case, twofold really. So understand that she has a plea agreement, which the state are going to recommend time served, but she could do up to 10 years. Desperately hoping that Judge A goes over the plea agreement and gives her 10 years. First question, could Judge A go more than 10 years if she sees it for that absolute horrificness that it is? Is there ways of upgrading, can't think of the right term, but bumping the sentence up? Second question, say she gets to 3 years, she gets deported and she goes back to Brazil. In her testimony, she was clearly shopping around for movie deals, Netflix, etc. I don't know if there's Son of Sam laws in Virginia or what have you. But if she's deported and she makes a ton of money on Netflix and suddenly gets all rich, could the family of Joe and Christine sue for wrongful death and try and take that money back? Are they able to do that from Brazil? How does that work? I know that's civil. And sorry, long questions, but that's it, I think. Hopefully Judge A prevails. I have faith. I'm praying to all the gods and spirits that she does. Everyone have a great Sunday, and thank you, Josh. Take care. Bye.
Lizzie, thank you so much. Calling from London, England. Let's put you on the map. Appreciate hearing from you. Great question. I'm sure something a lot of you have been wondering. This really stirred a lot of pots when the au pair, Magalhães, made these comments from the stand about having some Netflix deal in the works. So we're talking about the Brendan Banfield trial, a wild, wild, wild trial with the trial itself, not so wild. The circumstances and facts surrounding it, I think, are incredible. They're just one of these stories that you're not going to hear all that often. Let me answer your second question first, because this is the one that a lot of people have been curious about, is what about any money that this woman could make? The potential for her profiting off of this. How is that going to be handled? And everybody points to the Son of Sam laws. Let me just first say this. Those laws are as good as the enforcement. And what I mean by that is it's not like this law prevents companies from offering her money, right? It's not some sort of law where it like makes the production of documentaries illegal or the production of books illegal, right? You know, when you make a law like, you know, I'm trying to think of a good example, but there are, you know, the trafficking of drugs, Netflix can't participate in because it's clearly a crime itself. But the producing of a documentary or the publishing of a book is not a crime itself. Where it becomes, and it's not even a crime, where it becomes prohibited is in her receiving any money from that. So it would have to be enforced by someone, is kind of my long-winded point. And it would have to be enforced by the family. So they would have to go to court anyways to make sure that they received any profits of this. Well, they can also do that civilly. They don't need to wait on, you know, the criminal courts through these quote unquote Son of Sam laws to put that in effect. They can just go out and sue her right now. So very good point. They could get a massive wrongful death judgment out of her. And even if she doesn't have two nickels to rub together, sit on that judgment. And then it's rock solid that any money she makes, it's going to go towards that judgment because they've already got that judgment in hand. I think that's probably the smarter way of going about doing it, and probably the way that they would go about doing it. Now, can the judge go over sentencing for Magalhães, for the au pair? This is something listen, I've dealt with giving witnesses quote unquote sweetheart deals, cooperation deals all my career. This one seems a little much in my view, but I think she was also a huge part of that case. And they probably felt like they were not sure they would be able to piece this thing together without her. But going from what should have been double homicide, putting her away for the rest of her life, to a manslaughter where she may be getting out in the near future is pretty appalling to me. Can the judge say, I don't care what kind of deal you gave her, I'm going over all of that? problem is that in many times, and I don't know the circumstances of this because we are not going to be entirely privy to the circumstances of all of it, though we do know she is getting some sort of cooperation deal. A lot of that is seen as almost like a contractual agreement between the prosecution and the witness. In other words, she has a Fifth Amendment right not to testify. That is not insignificant. And so therefore, in order for her to give that up, she is getting something in return from the prosecution. Now, if the judge got in there and said, I don't care about that, I'm not going to honor any of that, that would be a tremendous problem. You can all understand. Not only for this case, but for any future case. What witness would ever trust the prosecution in that county and state ever again, knowing that judges can just disregard the whole thing? So realizing the profound ramifications beyond just this case, the judge is likely not going to go much farther beyond the sentencing guidelines. And that's the other question, is every single jurisdiction has their own guidelines, which is kind of where the judges need to stay in. In California, we have it's like a triplicate. We have low term, midterm, high term. And judges can vary in between those depending on mitigating and aggravating circumstances, but going out entirely outside of it is just going to create appealable issues, because a person's immediately going to say, you know, if somebody's looking at an exposure of high term 5 years and a judge gives them 10 or 15, they're just going to withdraw their plea. And I don't think there's a judge in the country that wouldn't allow them to do that. It's in some jurisdictions, though, no. Some jurisdictions, it's wide open. But I imagine in this case, it's a little more clearly defined, because why would she ever agree to something that would be so wide open? She wants to know, at least down to a few years, what it is that she's getting. But great question, Lizzie from London. And I appreciate you kicking us off this morning, because I know that was something a lot of people were curious about. Heather Cooper Smith, thank you so much for the super chat. That's so kind of you. Appreciate your generosity. Annalie Finch, good to see you. Thank you for the super chat. Says, happy Sunday fun day, everybody. Mrs. McGuire has been a member for 3 months. Thank you. Glad to be here. And Subi Sue, good to hear from you, has been a member for 11 months, everybody. Go Rams. Hit that like button. That's right. Go Rams. All right. Let's keep it rolling here. Where are we off to next? Hold on.
Hey, Josh and the CC crew. This is Chantel from Newcastle, Australia. Love your channel. Love, love, love. So glad I found you. Always trying to catch you live, but sometimes it's on the playback due to time, schedule, and my kids allowing me to. Have a question. So now that Alan Jackson has withdrawn from defending Nick Reiner, and Kimberly Green, the public attorney, is taking over, how does it work in terms of, so all the evidence and everything, and maybe whoever, all the professionals they've spoken to and everything with Alan Jackson, how does that work now that Kimberly Green's taking over? Sorry, my kids are coming in. Does all that go over to Kimberly Green and that team, or do they have to kind of start again and build their own case? Hope that's not a silly question. I was just thinking about that the other day, and I didn't know how it all worked, because I guess there would also be something based like on confidentiality. And, yeah, can you let me know? What are you getting me? All right, I better go. Thanks so much, Josh. Bye.
Chantel, I got to tell you, that message spoke to me on such a deep level. You are living the chaos that is the Ritter household. The fact that you were able to get through even 2/3 of your message without interruption from the little ones is pretty surprising to me. Thank you so much for being a supporter, for being a follower, for leaving us a message. Hello to you and the whole family and your little ones from Newcastle, Australia. And a great question, not a silly question at all. And this is what I meant when this is one of those questions where I've been doing this for so long. I've never really thought about this being something that people would even be curious about. But we're talking about the Nick Reiner case. Alan Jackson was the attorney, and he was the attorney for a few weeks. It wasn't, entirely an insignificant amount of time. In other words, I don't mean that he appeared on one date and by the next, 2 days later, he said, "Oh, sorry, I'm off." There was a good 2-3 weeks maybe before he withdrew from the case. No reason given. I think it really came down to a financial situation. It sounds like Nick just doesn't have money, or at least access to any money, because that's why he's going with the public defender's office. I've said this before, but it's not just that you get the public defender's office if you can't find another attorney. You have to qualify. You have to be, quote unquote, destitute. They actually take a look at your financials. If you've got a bunch of money sitting around and you just don't want to pay for a lawyer, they say, tough luck, go get one. The public defender's office is reserved for people who cannot afford a lawyer. So that to me indicates that he doesn't have any money, or the family is simply not giving him access to any money. A friend of mine who's an attorney as well that deals with estate planning pointed out, we've all talked about, and I know this wasn't your question, Chantel, but it gives us a good opportunity, points out that we've all talked about, well, doesn't he have a trust? I mean, Rob Reiner was a fabulously wealthy, very successful Hollywood director and producer and actor for a long time. They've got hundreds of millions of dollars. Doesn't he have a trust? Yes. But many of these trusts, and this attorney I was talking to called it a bad boy clause, have these clauses written into them about the behavior of their children and whether or not their own conduct can disqualify them. And wouldn't you think that a young man troubled with substance abuse for a long time and perhaps even mental illness would have those clauses in the trust? So it may not be, quote unquote, the family that's not allowing him access to the money. It may be the trustee is simply saying, no, this is the trustee, by the way, is not a family member. It is a person acting on behalf of the benefit of the trust. And that trustee is probably saying, I'm not forking over hundreds of thousands, perhaps millions of dollars to Alan Jackson to defend this. He can either get himself a reasonably priced bargain attorney or go with the public defender's office. That, I think, is a very real scenario. But I digress. What happens, though, in that period of time, it sounds like Alan Jackson and his team, and having known him for a while, I am sure that this is true, did a lot of work up front. Likely did some investigative work. Perhaps interviewed some witnesses, walked at the crime scene, and perhaps retained quite a few experts in the mental health field and consulted with those people. Where does all that work go and what happens now? Great question. First of all the quote unquote discovery is handed over, including much of the work product, because that work product is seen as being the property of the client. You are working on behalf of the client, right? So if you interview someone and notes are taken by an investigator and a report is written by your defense investigator, that's part of the file and that's part of the property of the client. And much of that is turned over to the new attorney. Retained experts. If money was paid, and those experts are retained. Now, I imagine those experts, if they were retained, were not given their full retainer, including a trial testimony retainer. So that's going to have to be worked out with the public defender's office. The public defender's office does have resources to hire experts, by the way. They can also have the court pay for experts. They can ask for funds from the court to pay for experts. Now, the court is not going to hand over the full freight price of a lot of these experts, but could still hand over enough that these experts could remain on the defense witness list. The only thing that usually doesn't get handed over is like personal thoughts, reflections, and notes by the attorneys. Whenever and this happens more often than you think, where people will just want to switch an attorney. It's happened to me. I have handled a part of their case. They decide, you know what, I want to go in a different direction, and they go get a different lawyer. Or we would inherit cases more often than not. And the only thing I would usually take out of the file is any kind of financial stuff, agreements between me and the client. That's nobody's business but our own, or my own personal notes. Because even though maybe that's work product, it's my personal thoughts. And so I wouldn't hand that over. But any kind of like interviews and reports that have been compiled, all that gets turned over. So none of that is lost. Great question, Chantel. Hope the kiddos got the snack or whatever it was they were looking for. But thank you so much for asking. Allie Foley, thank you for the super chat, says, love my CC crew fam. Go Patriots. Oh boy, Allie. Should be a great game today. And Allie also just gifted a membership. So thank you for that. Very kind of you. Deborah Guzman just gifted 5 Courtroom Confidential memberships. Appreciate you, Deborah, for all your support. All right, let's keep it rolling here. Where am I at? Here we go.
Hey, Josh and Tiff and Mods. This is Therapist You Know calling from the McMurdo Science Base in Antarctica. Hypothetically speaking, if a U.S. citizen were to get into some kind of incident with a non-U.S. citizen while both are stationed at an Antarctica research base, where would that actually go legally? Like, whose jurisdiction is that, or is it just international chaos? Just trying to understand who would be responsible here, you know, who would come looking, theoretically. Thanks, bye.
Therapist, you know, sounds like you've got problems at the McMurdo Science Station in Antarctica. But we did a little digging, mainly because all of our mods have a tracking device put on them. And we know that this call was actually placed from West Texas. So thank you so much for the call. This, I got to tell you, I'm sitting at a quiet location with my earbuds in, listening to these messages as I'm preparing for this. And this one had me fully laughing out loud. Thank you for that. TYK, there it is, the McMurdo Station. Hope you're staying warm. I can't imagine you're not, it's not chilly down there. But a great question. What happens, how does this work with crimes and citizens and things that take place out of the United States? How far is the long arm of the law of the United States to reach into other countries? Great question. Well, what we're talking about here is what's called extraterritorial jurisdiction of the United States. And other countries have this, but we'll focus on the U.S. First of all, the U.S. maintains jurisdiction over any U.S. citizen who commits a crime in another country. Okay, so you go to another country, commit fraud, commit even lower, level crimes, batteries, assaults, robberies. But certainly when you start to get into the more serious stuff like, sex-based crimes or murder, the U.S. is going to be involved in that and concerned about that. Now, doesn't necessarily mean the U.S. will want to prosecute you. Amanda Knox was something purely handled by the Italian government. The U.S. didn't see any need to get involved. But how about David Knezevich? You may have remembered this case. We actually did kind of one of our case notes episodes on this one. It was a fascinating case about the murder of Ana Maria in Spain, his wife that he followed there, allegedly. Problem is, he took his own life, and we're never going to get a full conclusion to this, which is really unfortunate because it was it's an important case and fascinating. But they brought his butt back from Spain, from Europe, and they were going to prosecute him here. Also, the effects doctrine, it's called. If crimes are committed outside of the U.S. that have a significant effect on the United States, that is something that we will prosecute. Ever heard of Nicolas Maduro? He was the self-described, self-appointed president of Venezuela. Well, we felt that he had committed crimes against the United States for drug trafficking, amongst many other things. So we went out and arrested him. That's what that case is, by the way. You know, it's got all the accoutrement of a international situation, but really what it comes down to is it's just a federal crime. He's been arrested for drug trafficking. Like many people in the US get arrested. He just happened to be the sitting quote unquote president of another country, and they went out and arrested him, but he's going to have a criminal trial. That's all. There's no difference in it. That was under the effects doctrine. And then there's other ways where, you know, there's things that they call the long arm jurisdiction of the United States, where if there's minimum contacts between outside crimes in the United States, usually we see that in a civil context. You'll see this oftentimes in cyber crimes that are kind of international. If we have a treaty with another country, the Office of International Affairs, a lot of this falls under their jurisdiction. But a really great question that the answer is, if there's a way and if there's a desire, then the U.S. can likely go out and get somebody and bring them back home and prosecute them, as long as they can get that extradition done. So great question. Hope you're staying warm down there in Antarctica, TYK, and thank you always for calling. All right. Let's keep it rolling here. Where are we on to next? Gossip and rumor. I know you. Kathy's in the chat, says, what about crime at the International Space Station? Why would that be any different? And by the way, they got to come back sometime, right? So there's not even really that much of an extradition concern there. They're just going to wait for them to fall from the sky. But yeah, if it's a crime involving a U.S. citizen, either victimized or committing the crime, I imagine the U.S. will decide that they need to prosecute. You imagine taking a jury view of that crime scene for a murder committed at the International Space Station. I would like to actually be a part of that jury. By the way, please put up that comment one more time. Tomorrow, Monday, Kathy from Gossip, Rumor, and Innuendo will be on this show at 5 p.m. Pacific, 8 p.m. Eastern to share with us more of her fantastic thoughts about not only international crime, but the updates in the David case and Brendan Banfield and whatever other goofy stuff we can think of. So please tune in. Thank you so much for being here. Appreciate your support. And that's a great question too. All right, let's keep it rolling.
Hi, this is Don in Hoboken, New Jersey. I have to make a correction about the timing of the OJ trial. The murders were in June of 94, and the acquittal was in October of 95, a year and 4 months apart. Still pretty quick, but not as quick as 4 months. I watched it. I lived through it. I will remember that timeline forever.
How dare you confront me with facts, Don? One of my dudes from Hoboken, New Jersey. Let's put you on the map. You are right. I got more than your comment telling me that, hey, you got it off by just a year, Ritter. What's a year? Not too much. But yes, to be correct, I never am ashamed in saying when I'm wrong. The murders took place of Nicole Brown Simpson and Ron Goldman on June 12th of 1994, and it was not until October 3rd of 1995 that he was acquitted, OJ. Still neck-snapping speed for a case like this. There was contemplation of the death penalty on this case. Like, this case, by most standards, would have taken 4 years to get to trial. No joke. There are cases that take death penalty type cases, double homicide, way longer than that. So the fact that this went from murder to arrest to acquittal within the period of less than 2 years, within the period of a year and change, is still remarkable, and still kind of my point about them not waiving time remains true. But thank you, Dawn from Hoboken, for correcting us. Never let it be said that we will allow inaccurate information to be in the YouTubeosphere coming from Courtroom Confidential. So appreciate you, Don. Thank you for calling in. Tiff says, thanks, Ann Potter, for supporting the mods with coffee. That's very kind of you, Ann. We appreciate that. All right. Let me just get all my ducks in a row here. Here we go.
Good afternoon, Joshua and CC crew. This is Shelley again from Wicklow, Ireland, and I just want to say thank you so much for answering my first question, and this is my second one. I've just finished watching your Sunday Fun Day on Catch Up, and it's led me to a query. Could you explain felonies to me, please? I know it's a serious crime, but I know California has felonies and misdemeanors and infractions, and Ireland, we have a very different system here. And I was just wondering if you could maybe explain what a felony would be as opposed to a serious crime, or is that the same thing? And what would a felony misdemeanor be? If a misdemeanor is a misdemeanor, how would it be a felony misdemeanor? Thank you very much. And I hope you all have a lovely Sunday Fun Day. Bye.
Thank you so much, Shelley, calling from Wicklow, Ireland. Let's put you on the map. Appreciate you being a follower and supporter. And this is a great question. Another one of those questions that I'm sure a lot of people wonder about, and I don't give enough time to explaining. I, assume that we're all kind of speaking the same language here, but maybe not. And so here's a little vocabulary lesson from Courtroom Confidential on what is a felony, what's a misdemeanor, what's an infraction. They are all different. And no, there is not a thing called a felony misdemeanor. They are very separate. But it does come down to, for the most part, exposure. Yes, it's a level of seriousness, but it's also a level of exposure. Felonies are the most serious, the most egregious. Murder, capital murder, all felonies. Felonies, though, are for anything where you're going to serve state prison time. You're going to go off to the state prison system. I'm going to tell you how it works in California, because that's what I'm most used to. And I think that's kind of a standard across the US, but jurisdictions may be different. But in California, this is also any crime where you're looking at, doesn't necessarily mean you will be sentenced to, but where your exposure is over 1 year. So 16 months usually is the lowest that you'll see. But even if you get sentenced to probation and don't serve a day in jail, if your exposure includes any time over a year, it's considered a felony. And if you are sentenced to time over a year, you're going off to state prison, which is not just a matter of where are you being held. It's a matter of who is even presiding, over that. You get handed off to the Department of Corrections rather than staying within the county sheriff's department. So it is a significant kind of housing situation. Misdemeanors, therefore, are anything where your exposure is less than 1 year and you're usually only going to county jail. These are things like DUIs, lower level domestic violence, lower level assaults and batteries. Some things are only going to be felonies. Murder is only going to be felony. Armed robbery is only going to be a felony. You'll never see a misdemeanor murder. But there are things that we refer to as wobblers, where they can be charged both as a misdemeanor and a felony. What would be an example of this? Assault with a deadly weapon. You can have an assault with a deadly weapon that is a misdemeanor, or it could be a felony, depending on the injuries perhaps involved. But depending on what the weapon was that you were being assaulted with. Assault with a deadly weapon with a gun is very different than assault with a deadly weapon with a frying pan. And a person who is put in the hospital from that frying pan is very different than somebody that never even got touched with a frying pan. But both of them would be considered an ADW. It's just one might be a felony and one might be a misdemeanor. And you can charge something as a felony, pardon me, and then ask that it be reduced to a misdemeanor because it's a wobbler and the judge can do that. And then there's this lowest category called infractions. Infractions are usually just violations of a municipal code, violations of a citywide ordinance, jaywalking, speeding, usually kind of vehicle code related infractions. It could be building code things. It could be, failure to properly have the right mailbox height. You know what I mean? These are things that can be violations of a municipal code, but you're not looking at jail time. You're not looking at a loss of your liberty and freedom. So it's not really a crime. It's an infraction. You're usually just going to get a fine, if anything. And then there is something that we call wobblets, where they're misdemeanors that can also be infractions. So sometimes the lowest level misdemeanor, drunk in public, you could lower that down to an infraction where somebody's just looking at a ticket and therefore nothing on their criminal record. Hope that explains things. Hope that is something that makes it easier to understand all of this. But all of these are serious, I guess, depending on which perspective you have. But those are usually the categories that we're dealing with are felonies and misdemeanors. Thank you so much, Shelley from Wicklow, Ireland, for asking the question. Best Nancy, thank you so much for your generosity and super chat. Says for all our beautiful mods. That's very, very kind of you. And Anonymous back again. Thank you so much for supporting the mods with coffees. Appreciate that. I wonder how long Anonymous has been a member. Not a House defendant has been a member for an entire year. Happy birthday, says, I'm very skeptical of someone with a plea from the jump. Oh, interesting. Like if they plead guilty from the very beginning. We're actually going to get to, I think, a question kind of dealing with that. All right, let's keep it rolling here. Great questions already, and you guys have been fantastic with the support and super chats. Always appreciate that. All right, where are we at?
Hi, CC crew. Hi, Josh. Hi, Tiff, Kaylin, mods, everyone. This is Trina from McHenry, Illinois, also known as Trina Bina 81. Longtime listener, first time caller. My question is on Ashlee Buzzard. When they arrested her the very first time and let her go, do you think that gave prosecution and police a better foundation, or did they get better warrants and or phone tapping warrants so they could get more information on her since that very first arrest where they had to let her go? And do they now probably have much more information since that? But I'm just wondering if since the first time they got better warrants or phone tapping. Anyways, thank you so much for all you do. I absolutely love this community. Love you, everyone. Thank you so much. It's just such a fun place to be. Everybody have a great weekend and happy Sunday Fun Day.
Happy Sunday Fun Day. Trina from McHenry, Illinois. Let's put you on the map. I love this stuff. I love the first time callers and people who've been with us for a while and supporting us and finally decided to take the leap. See, Trina, it wasn't that bad. Everybody out there who's been listening for a while, we get, thousands of people watching, but not as many calling. And you can take a lesson from Trina that I don't bite. You're going to ask a great question, and we would love to hear from you. Thank you, Trina, for doing this. And it's a great question. It's a great question. I love this question. Trina wants to know, in the horrible case of Ashlee Buzzard, she's accused of murdering her 9-year-old daughter, Melody Buzzard. There she is, beautiful young girl. I love that smile. Look at that little face. Look at how that genuine smile she has. And to have her robbed from this earth by her own mother is just nightmarish. But Trina wants to know, Did the first arrest give them an advantage in their investigation? And my answer to you is absolutely, I think it did, and by design. So the police, if you guys remember here, did something clever. When Melody first went missing, and there was a lot of suspicion as to where she was, they didn't have enough probable cause to arrest her for murder. And I know a lot of you might be thinking, well, they should have. Think about these horrific circumstances, okay? What if Melody's body had not been discovered yet, and there was some period of time? And what if they had decided to go out and arrest her for murder anyways? And she says, great, want my prelim. Give me my prelim now. And that prelim is kicked. Or worse yet, she gets to trial and she gets acquitted and double jeopardy attaches because they didn't have enough evidence to arrest her. They had a lot of suspicion, but not beyond a reasonable doubt evidence against her. We could be looking at a situation where this woman might have gotten away with murder, but they didn't do that. And they were patient, and they were patient to the agony of the entire community. And I understand what they were dealing with. But what they did do to try to rustle up some information and perhaps a confession out of her is they arrested her for the first thing they could prove. They felt. And that was for this false imprisonment of someone else. This was I don't know if it was like an amateur reporter or somebody who had gone out and talked to her and then felt that he was threatened by her. And police said, okay, sounds good enough to me. Sign this affidavit here. Let's put together a police report and let's go out and arrest her. And interestingly enough, exactly what I just said happened. It got dismissed because they really didn't have the evidence to prove that case beyond a reasonable doubt. But in that period of time, they went out and secured a bunch of warrants, and they searched her house and they searched her car. And I bet you they searched her digital devices. And I bet you they even got a tap on her because they were watching her every move, because this wasn't about some low-level misdemeanor false imprisonment case. It was about the murder. And I think that those warrants, because they likely secured a lot of that evidence that this woman may have gotten rid of if they had just sat around on their hands and done nothing. So to answer your question, Trina, I think that what we're going to find when this goes to trial is that much of the evidence that they gathered, they found other bullets matching what they believe were the bullets used in the murder. Whatever other evidence they collected, we may find was the result of those original warrants from that case that got dismissed that they're going to use in the murder case against her now. So good on those law enforcement. And I hope that community gets some justice, because this is just evil like I can't imagine. Great question. Trina from McHenry, a first-time caller. Debbie Harrow, you're so kind and generous, says, my favorite show, my favorite sure coupler, the Ritters. Josh has good guests as well. If you're not a member, please join this fun family. Great mods. Well, listen to Debbie, everybody. Do not upset Debbie. Please sign up. We would love to have you. Love to have you as a part of the community, and I hope that you join. And Scotch's mom has done it for 5 months. Says, love being a part of the CC crew. Well, we love having you here. Thank you so much. All right. Let's keep it rolling.
Hello, Josh, Mama Tiff, mods, and everyone. This is Subi Sue from Reno, Nevada. It's been a while since I called in, but Josh, just so you know, it's the biggest little city in the world is our little slogan here. But my question is about evidence, and this may be really not a great question, but I wonder myself on the evidence, what is the difference between evidence, or is there a difference between evidence and evidence that's published and evidence that's under seal? Now, I imagine under seal means nobody can look at it, but is there an instance where it becomes regular evidence? And yeah, the difference between all three of those. So just a quick question, and I hope you guys are doing well. Thank you.
Subisu, Reno, Nevada. I already forgot the slogan. Biggest little city in the world. Is that right? I don't know. They're both looking at me like, I don't know. I think I'm right. Tell me if I'm wrong. But Subisu, thank you so much for being a part of this community, and thank you for asking the question. Again, this is one of those ones that I am not all that a question I never would have thought to answer otherwise. So I'm glad that you asked it. Subisu wants to know, what's the difference between published evidence, evidence that's under seal? Does it ever go back and forth? The answer is we have an open court system, right? So usually once evidence has been admitted in court, that is considered public. And that's when media outlets can start even requesting some of that. If it's photographs, things like that, they can start requesting it because it's considered to be a public, on the public record at that point. Now, in some instances, things are done off the record, in chambers, and sometimes those proceedings are under seal. They might clear the courtroom in some respects. Those proceedings can be under seal, and evidence admitted can sometimes be put under seal, or motions can be filed under seal. And this is usually to protect the integrity of perhaps defense strategy that they don't want getting out there. Things that are not a part of the official public record, or to protect the integrity and safety of witnesses and their identities. If that stuff, though, becomes part of the trial and public record, then it's no longer, they have to unseal it, in other words, to make it part of the trial. You cannot have evidence submitted as exhibits and part of a trial record that is still remaining under seal. So the answer is some of that stuff, sidebars, in chambers conferences, may remain under seal if it's never a part of the evidence going in front of the jury. But if it does, then we're going to hear about it. And I hope that clears that up. The answer is that even after the trial, if some discussion, if some evidence was considered for whatever reason important to keep under seal, it will remain under seal even after the conviction of a person and for years beyond that. So great question, Subisu. Reno, Nevada, thank you so much for asking it. And we always appreciate having you. Eroy, you're the best. Tiffany's doing one of these, in case you guys don't know, behind the scenes. Thank you so much. That's very, very generous and kind of you. We're blown away. 20 Courtroom Confidential memberships. There you go, everybody. Hope you enjoy. By the way, we just had a members only live that we did yesterday. So for those new members, please go check it out. Love you, Eroy. Love having you a part of the community. And welcome to all the new people who received one of those. Fantastic. Kaylin, thank you for the super sticker. Appreciate you and your generosity as well. You guys are fantastic this morning. And Michelle just became a YouTube member. Thank you, Michelle. Welcome aboard. You're not going to regret it. We will make you happy you made that decision. And Blimey Hermione, did I say that right? I think I did. Thank you for the super chat. Says, hi, Josh. Ashlee is being charged in California, but it seems it should be in Utah because that's where Melody was killed. Great question. And you must have hacked my computer and saw my notes because I think somebody actually asked that question. So I'm going to answer it. I just don't want to steal my own thunder and get to it beforehand because I feel like somebody else did ask it, and we're going to get to that. If we don't, remind me and I'll answer it anyways. But thank you, Blimey Hermione. All right, let's keep it rolling here.
Hi, Josh, CC crew and mods. This is Tracy from Orlando, Florida. I was on the replay crew for last Sunday, and I have a question about extradition. I know that if the U.S. requests extradition from another country, that country can say not unless the death penalty is not an option. Since a little more than 50% of our states have the death penalty, can a non-death penalty state make the same request? Thanks, guys. Have a great Sunday fun day.
Tracy from Orlando, Florida. What a wonderful question. Can somebody be extradited, or I guess it's more about, can a state refuse to extradite someone to another state because they simply don't agree with the laws on the books in that state? Great question, because sometimes states do have differing laws, especially when it comes to the death penalty. Some states have it, some don't. Would they want to extradite someone when they know that the state where the person is being held is a non-death penalty state and they're sending him somewhere where they could be looking at the death penalty? Can they refuse to do that? Well, this is all high-level stuff. I'm just a small-town defense attorney, and so I had to call on somebody that I felt could give you a better answer. So I phoned a friend.
Hi, Tracy. That's a great question. Let me introduce myself. My name is RJ Dreiling. I'm a criminal defense attorney. I was an LA County prosecutor for 15 years. So traditionally in the United States, each state was treated as its own country for purposes of extradition, which means that certain states were just refusing to turn people over to other states. That came to an end with the Supreme Court case in 1987, where the Supreme Court said, hey, listen, if one state wants another person for a good reason, that other state has to turn them over. Now, what has not been settled yet is if a state that refuses to recognize the death penalty has to turn someone over to another state that wants to use the death penalty. There was a governor in Rhode Island who refused to turn someone over to the federal government to face the death penalty in 2011. And back where I'm from originally in Kansas, the governor there is saying that she's thinking about not turning people over to states that want to implement the death penalty. So it's going to be interesting to see how it plays out. It's probably going to start on the lower level, lower federal courts, and eventually probably make its way to the Supreme Court, who's going to weigh in and make that decision. Again, great question, Tracy. Take care.
Great answer, RJ. This is my buddy, RJ. I've known him for a long time. He was a prosecutor in the DA's office along with me. He recently left a little after me to go into private practice as a defense attorney. There's his website. We would love for you guys to check him out. And that's a great answer to that question as well. Basically, we've never really had to deal with this just yet. And the reason for that is usually the states come to some sort of agreement. And usually the death penalty is not so much of an issue to the state that's making the request that they will not make some sort of agreement to not pursue that in order to get the body, the defendant, to that other state. So it's been avoided. But it looks like maybe not for all that long. Maybe we will have an answer to all of this. And it's going to be a really fascinating Supreme Court question, too. The Supreme Court's going to have to weigh in. This is going to go straight to the Supreme Court because it's dealing with the laws and a disagreement between the states, which is purely within their purview. And I don't even have an answer for you for how I think they would rule on the whole thing. It's kind of a, at the real foundation of our Constitution of, where does the independence of the states end and begin as far as, these interstate agreements to extradite people. So great question. And just a kind of a unique thing about the United States, that these jurisdictions are considered their own sovereignties in many, many ways. So thank you again, Tracy from Orlando, for asking the question. And thank you so much to my friend RJ for answering it. All right. Oops, I keep doing this. Let's keep it rolling here.
Hey, Josh, CC crew. Any confidential Grizzlies in the chat? This is Court Lurker calling from Spokane, Washington. And I don't know if this is a stupid question. If it is, I apologize. But I am curious as to witnesses. When they are subject to recall during the guilt phase, does that also mean for the penalty phase? Or is that a whole separate group of witnesses and subpoenas and whatnot? Just curious. I thank you for everything you guys do and all the hard work you put into your channel. Have a wonderful Sunday fun day, everyone.
Court Lurker from Spokane, Washington. Love hearing from you. Great question. No, it's not a silly question. It's a great question. When a person is subject to recall, does that include both phases of a trial with a potential penalty phase? And the answer is yes. When we say that term subject to recall, you oftentimes hear judges do that, saying, is this witness excused? Are they subject to recall? What are they talking about there? They're talking about, is the court going to maintain jurisdiction over that person? Remember, to get somebody to come to court, especially someone that may not want to come to court, a judge can't just sit on their bench in their black robe and say, I order Josh Ritter to come to court. They have to somehow gain jurisdiction over Josh Ritter. How do they do that? Well, they have to get me served with a subpoena. The court has subpoena power. The prosecution can write out subpoenas. The defense can write out subpoenas, but those have to be served on someone. So we're going to talk about in a minute here what happens when you don't respond to a subpoena. But once that subpoena is put in your hands and you are served, that is a court order, and you are now under the jurisdiction of that court. And when you show up to court, we want to know, how long are you maintaining jurisdiction over that person? If that person is released, that means they're no longer under subpoena, and they can go about their day. And if you say, hey, I'd like you to come back to court, they can say, go pound sand. Unless they are considered subject to recall, which is the court's way of saying you're still under jurisdiction. The orders of the subpoena are still in place. And I'm ordering you not to sit in the hallway every single day, but to be subject to recall. Meaning, if prosecution or defense calls you and says, I'd like you to come back, you have to come back. And it's not just a request, it's an order from the court. You'll see this happen most times when the prosecution calls a witness and the defense may want that witness back in their case. And so they'll say, Your Honor, subject to recall by the defense. And they may call that person back, but they just don't want to have to reserve that person with a subpoena. That includes the penalty phase, because even though the penalty phase is a separate part and we call it a bifurcated trial, it's under the same case number and the same trial. It's considered the same trial. So those people could be subject to recall for the penalty phase if they're important to something to do with the penalty phase. And I hope that answers your question. I think I've hit every point that you might be curious on that. So thank you, Court Lurker. I love that. Again, you guys are the smartest community on YouTube, and I always appreciate you asking these questions that I might not have thought about myself. All right. Let's keep it rolling. Not my fault. I see a spinning wheel.
Hi, Josh and everyone. This is Lynette from Exeter in England. My question is about witnesses in a case and how the prosecution decide who to bring and what order, as to whether you come out with a big witness to blow the case and start it. Do you build it up slowly with experts and then give a final witness that brings it all together? How do you decide to do your presentation? And secondly, with any expert witness, like in the Banfield case with the blood spatter analysis, you're obviously asking for their opinion or their expert opinion of what they found, and then they would summarize. Why then is the defense allowed to object to their expert opinion? I don't get that bit. All right. Many thanks for your answer. Cheers.
Lynette, let's put Exeter, England on the map. Thank you so much, Lynette. Love hearing from you. Great questions. Let me answer the second one first. How in the world do you object to an opinion when it's just an opinion? Well, There's a few reasons why you might object to it. One, you'll often hear attorneys make an objection based on foundation. What that is shorthand for saying, I don't feel that this expert has properly established that they can give this opinion. Okay. So maybe, I mean, a good example might be if you're asking someone, let's say they're a mechanic and your case is involving a car accident, and you've got a mechanic up there to talk about the how the vehicle works and how the vehicle accelerates and how the vehicle handles under different conditions. And then the person examining that witness says, and what would you expect to be the injuries caused to someone hit by a vehicle like that going 80 miles an hour? Well, now you've extended it beyond their expertise in mechanics into a question of, physics and injuries and the dynamics between a moving vehicle and a human body. That would be something that you might get an objection to on foundation. They have established themselves as an expert in one area, but perhaps not in the area that they're being asked a question on. Another situation might be what's called an improper hypothetical. So one thing that experts are not allowed to testify to is what's called the ultimate question or the conclusion of the matter. In other words, you cannot ask an expert, is this person guilty? In your expert opinion, is the defendant guilty? That is a question purely for the jury. But what you can do is present to them a hypothetical. Expert witness, in this hypothetical, if a person was traveling 80 miles per hour and they had been taking alcohol and they had been blah, 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 and you do your best to present a hypothetical as close to the facts in question, and then say, in your opinion, X, Y, and Z. You can do that. And it's a clever way of essentially asking the same question, but you're asking it as a quote unquote hypothetical. Well, many times they will object that the hypothetical is not accurate, that the hypothetical doesn't include all the facts, or that the hypothetical misstates some of the facts. And therefore you'll get an objection on an improper hypothetical, or you'll just get an objection on that they're being asked to give an opinion as to the heart of the issue in question for the jury. So those are some of the areas where you might see an objection to an expert opinion. To your first question, how does the prosecution decide who to put on first? It's really stylistic. I think a good strategy, a strategy I try to employ as a prosecutor, is to always start with someone strong. You certainly don't want to come out of the gate with a weak witness, somebody who's going to struggle. So you hope that that first witness is somebody strong. Lots of times you might put on your investigator to kind of establish the whole roadmap for what the jurors are about to hear. I think you usually are saving your experts for the very end so that they've heard all the facts and now they're getting the opinion at the very end. I know that some prosecutors try to start big. Maybe they'll put on the victim at the very beginning or an eyewitness at the very beginning and just start with this big splash. I always think it's a smart strategy to kind of present your witnesses in chronological order. And the reason for that is the jurors don't know the story. They've heard the opening statements and it's given them somewhat of an idea, but it's also helpful to present it in as much of a story arc as that you possibly can. But end of the day, a lot of times it's going to come down to who's available. I mean, sometimes you've got witness issues where somebody's not available one day and you've got to put on who is sitting in the hallway. And sometimes that means calling people out of order. Sometimes that even means putting on defense witnesses in the middle of your prosecution case, because those defense witnesses are only available right now. So they'll ask to go out of order in the case presentation altogether. So a lot of that, when you see why are they calling this person now and why are they making it all confusing, it's just who do they have sitting in the hallway that's available to testify, and they've got to fill up court time and not waste everybody's time trying to get it in the perfect order. It was, I got to tell you, something not talked about a lot. It is probably the most difficult part of putting on a trial is the coordinating of the witnesses. So much of that logistic work, it's, you know, asking the questions, you can handle that. Making the arguments, you can handle that. It's wrangling all these witnesses and keeping everybody in mind and who's where and is that person available and why aren't they in the hallway, and go find that person. I found out early on in my career, you just have to inconvenience people. And if people are sitting in the hallway for hours at a time, waiting to testify, sorry, but not sorry, because I can't risk the idea of trying to be convenient to you when I have a judge who's saying, who's your next witness? And I've got, you know, an hour before our lunch break and I've got nobody sitting in the hallway. Lessons learned very quickly in the DA's office. Great question, Lynette, from Exeter. Appreciate you asking. All right. Eroy. God, you're fantastic. Thank you so much for the super chat. Says Shannon Burgess example of unqualified expert. There you go. Yeah. I mean, you know, these people are experts on sometimes very particular things, and asking them to go outside of that is a problem. All right. Let's keep it. Why do I keep doing this? I feel like it's my first time figuring this out today. All right. Let's keep it rolling here.
Happy Sunday Fundy, Joshua, Tiffany, Kaylin, the greatest mods in the world, CC family, and guest, it's Alicia K. Mayo, Humboldt, Tennessee. Joshua, let's talk Taint Teams. My question is, and I've often wondered this, and forgive me if this is a silly question, but at what point, if ever, does the rest of the team that's not on the Taint team find out what the Taint team knows? Or do they ever find out? The only situation I can think of is once a case is completely done, aka the death of their client, whether it be by natural causes or state-sponsored. Look forward to your answer. Hope everybody's having a great Sunday Funday. Thanks, y'all. Bye.
AKM from Humboldt, Tennessee. Always great to hear from you. Thank you so much for asking this question. Taint Teams. Well, let's talk about, first of all, what they are. So we're all speaking the same language. In a case where there is the potential that investigators, prosecutors could stumble upon evidence that they should not see, they will employ what's called a taint team, or you might call it a dirty team. They will put up a wall between those teams. Sometimes they will even assign a special master to be involved to make sure that there's no bleed over between the evidence that the clean and dirty teams are seeing. And you'll see this most often. The clearest example is when they're going to perform a search warrant on perhaps a attorney's office. Very, very rare, but sometimes does happen. Or they're going to perform a search warrant on a defendant's home or office where they believe that that person's already retained counsel and there may be attorney-client privileged information. That's what they're trying to avoid, is if they stumble upon and see attorney-client communications, they've quote unquote tainted themselves. And they then are going to have huge problems if that same prosecutor's office tries to proceed with the prosecution having seen that evidence. Courtney Clenny is the first example that comes to mind. This was a big problem in that case because they didn't do this properly. And they did stumble upon some attorney-client privilege information, and it did disqualify the original prosecutors from handling the case. So they'll take care of all of that preemptively by having a team that doesn't view the evidence, only views the evidence that's considered clean, and then another team that may see everything, and they know all of this tainted attorney-client information, and the two will not communicate with each other. Well, how long does that last? Forever is the answer. You're right, AKM. It could mean to the death of the defendant, because we don't ever want that to be a problem, even on appeal. And this is something that would happen. Prosecutors, investigators, if they're part of that quote unquote dirty team and collecting all of that evidence, they're just never going to be involved in that case. And they're never going to talk to those prosecutors and investigators about that case. And that is a very important thing that is done. But it's a great question. And it's a practice that you'll see come up every now and then when you hear them talking about appointing a special master, who, by the way, just so we know what we're talking about, is an independent person, not a prosecutor, not in their office. It's an independent person, usually, you know, maybe like a former judge or a law professor or somebody who's kind of well established in that community that can be trusted to understand the difference between what would be privileged information and what wouldn't, and the person making that call on the fly so that there's not a problem down the road. Great question, AKM from Humboldt, Tennessee. Appreciate hearing from you. Kathy Mama Bear, thank you so much for supporting our mods with coffee. To Afton, Sonia, and therapists you know. There you go. Kathy, you're the best. All right, let's keep it rolling. Where am I here? Here we go.
Hi, Josh. Hi, Tiff. Hi, mods and CC crew. It's Little Miss Red Velvet here from Manchester. I wanted to ask a little bit about something else tonight, and it's about, we've all been watching the Brendan Banfield case on Courtroom Confidential Live Trials. We've had great fun, by the way. I just wanted to ask about the preparation that you put into your defense, as the lawyers in this particular trial have not been great, especially with the technology. I wanted to ask is, do you get a chance to practice with the technology or do like a test beforehand? And also, how do you decide what order you have the witnesses for the trial? And also, do you prep the witnesses beforehand, which I'm sure you do, but just a little bit about the preparation of a case, really, Josh. I'd really like to know. Thank you. Look forward to seeing you on Sunday Fun Day. Take care. Bye.
LMRV from Manchester, England. Thank you so much for calling in. Another great question. Great to hear from you. Talking about the Banfield case as an example, but I think it's something that we can learn from watching many other cases. And I love this question. Does the defense get access to technology? There you go. Ahead of time, because it seems like it's their first time seeing a computer sometimes. The answer to this is yes. The answer is also the tools are as good as the person using them, right? I mean, you know, you got to pick up the hammer ahead of time before you start using it, even if you've had access to it. This is something that would always crack me up. And it does seem like it's kind of not to be stereotypical here, but it does seem like there's a certain type of defense attorney who's been around forever and has seen technology advance beyond their experience that does seem to struggle with these new advancements in technology. And they're not all that advanced technologies, by the way. But I would always crack up when a defense attorney, would struggle to understand how to put up an exhibit in the courtroom or struggle to understand how to operate their own PowerPoint during their closing arguments. And it was always kind of like, come on, dude, we're not doing advanced AI stuff here. This is something that you should probably have figured out before you stepped in the courtroom. I certainly took great pride in making sure that my tech flowed smoothly, because the last thing I want to have happen is the jurors to be wondering about the technology and why I'm having difficulty rather than hearing the presentation of the case. And to your questions about the defense and how do they decide about witnesses and do they prep their witnesses ahead of time? They should be. absolutely prepping their witnesses ahead of time. You know, you should be prepping every single one of your witnesses. And there's a difference, and a line is definitely drawn between prepping your witness and feeding your witness testimony, right? I mean, you're not coaching a witness. That is a bad thing. Not only can it be borderline unethical, but it can just lead to problems in court that become abundantly obvious to jurors if a witness is coached. But prepping them, telling them this is how things are going to work in court. These are the questions I'm going to ask you. These are the things I want you to be familiar with. Take a look at the police report where you talked to the cops before. Take a look of the prelim transcript where you testified before. These are the questions you're going to be asked. That is a huge part of having a successful presentation of a witness. And as far as like the order goes, same deal. I think that you try your best to establish some sort of a theme as the defense, not as important as it is for the prosecution. But again, you're usually just dealing with who do you have available, who's sitting in the hallway that you can actually call. The defense usually not putting on as elaborate a case as the prosecution, and much of their witnesses are just kind of being called in rebuttal to what the prosecution has done anyways. But great question. Little Miss Red Velvet from Manchester, England. Appreciate you calling in. Are you guys having fun? Are you all staying warm? Are you all staying juiced? We've covered a lot of territory so far already. We got a lot more to go, so I'm going to keep rolling here. Chicago Marie, thank you so much for supporting the mods with coffees or hot chocolate. Oh, I didn't know they had a choice. There you go. All right, where are we off to next here? Hold on. I will figure it out. No, I won't. Where are we? Here we go.
Good morning, Joshua. Hi, Tiff. Hi, everybody in chat. Ain't no hollowback girl here from Kawarthas in Ontario. Last week, Dr. Michael McKee was indicted and extradited back to Ohio to face murder charges in the Tepe case. Why then not the same for Ashlee Buzzard? Why isn't she being extradited back to Utah, given that Melody's remains were found there? And a bit of a shocker for me was learning this week that a judge placed a permanent gag order on the warrants issued by the Santa Barbara Sheriff's Unit. Maybe you could give us a comment on that. And then in Virginia, I'd like to just talk about that 6-year-old that shot his teacher back in 2023. He'd be about 9 years old now. And he's being taken care of by his relatives who have enrolled him in school. And Josh, this is a two-part question as an attorney and as a dad of children as well. Do you think that there should be a registry similar to that of when sex offenders are released back into the community, whereby the parents are notified who have children going to that same school that there's a kid there that does have a history of violence? I would be curious to see what your feelings are on that. And lastly, the au pair affair with no hair, Banfield and Juliana. I think that they should also be further.
ANHBG from Kawartha, Ontario, Canada. Great questions. I'm going to answer as many of them as I can, and the ones that at least I was able to get the full question from you, but great stuff. I love this question about the registry for children who have committed crimes of violence and maybe moved to another school. And there's no simple answer to this. This is a really interesting topic that we could talk about for a while, because there's competing interests here, which are both very important. First of all, you've got the parents at the school, and you asked me both as a lawyer and as a parent, the parents at the school where this troubled young person might be transferred to. Absolutely. As a parent, I'm sitting here going, we should absolutely be informed of that. And the school should be informed of that because maybe they need to have other resources available, security measures in place, certainly you would think, just from a purely liability perspective, that would be something they would want to do. Okay, well, don't be so quick, because on the other side of this is the very compelling interest of the privacy of the minor. And I say that because that's the pivotal point there. If this were somebody at a college where you're having someone transferred from one college to another and they're an adult, should that new college be informed? The answer is not only yes, but yes, they are required to legally. And this does happen, where somebody might get kicked out of one college for some sort of misconduct. The new college is going to be informed and has to be. And in some cases, that person might be under a legal requirement to inform that new college. Doesn't work the same way when the person's a minor, because we have these concerns about the privacy of minors. Juvenile records are under seal. So how do you deal with the two of those? I don't know. I don't know. I feel like there should be, and I've not confronted this personally, but I feel like there should be something, maybe not the details of what it was that the minor had done, but certainly that they should be informed that the minor needs extra resources and that there is a trouble in behavior. I mean, the idea of transferring someone to another school and just not informing anyone about anything seems like you're just asking for trouble, and you're asking for liability, which is probably their biggest concern, is about getting sued. Great question. I wish I had a better answer for you on that, or how it's actually done. I'll try to find out. I was not able to find out. Okay. Let's get into your other question, though, about Ashlee Buzzard. A lot of people have been asking this. Why was she not extradited back to Utah when that is where the crime took place? So this is kind of to our question earlier about where does jurisdiction over something exist? And I will juxtapose the Ashlee Buzzard case to the Michael McKee case with the murder of the Teppies. So he lived in Rockford, Illinois. He was extradited from Rockford, talking about McKee, back to Ohio, where he's going to be prosecuted. Well, why was that done and it wasn't done with Ashlee Buzzard? And the answer has to do with partially it's where the crime took place, but then also a lot of it has to do with where is the impact on the community, and also probably an agreement between the states. I am sure when it came to Ashlee Buzzard that Utah said, you know what, this is a crime that impacts the community in California. It does not impact the community in Utah beyond the idea that it took place here in the wilderness, but it didn't involve citizens of Utah. Melody was never lived in Utah. Ashlee never lived in Utah. It's just that the crime happened to have taken place here, and there's no real connection to the state. And I feel that though Utah could have said, well, it's a crime committed in our boundaries, and maybe they could have thought about that, I think that they realized that this is something better. The justice is better served in California. And the reason why California maintains jurisdiction is that they have actually said this. She formed the intent, which is an element of the crime, in California. And I think that's true too. When she set out on that deadly road trip, she had already decided what she was going to do, and that intent was formed in California. So it's not like it might be a very different story if it was a crime that you could say from its inception took place in another state, but it was a crime that does at least have some of its elements having been formed in the state of California. And I think that's why they wanted her back and why they extradited her. But more than anything, it's a loss to the community of California more than it is to the community of Utah. But great question. And I think that, oh, no, the gag order was the other part that you asked. I hate these things. I think they're being overused. I really do. Gag orders traditionally are to prevent the unnecessary and harmful dissemination of information on a case so that a fair trial cannot be had. That is a big concern, right? Judges' primary concern is to protect the sanctity of their case, to make sure that there is not outside influence unduly affecting that case. But I feel like judges are starting to just use this in any high profile case because it's just easier. If they don't have the media involved, they feel that somehow just makes things quieter and easier for them. And that is not what gag orders are supposed to be used for. And what it's doing is it's creating not only a lack of transparency, but I think a lack of trust in the criminal justice process. And that's damaging. When you start to shut down things and not allow information, and by the way, most times attorneys are, even without an official gag order, they're under orders from the court to not talk about, undisclosed evidence in the case. They shouldn't be just out there blabbering about all the evidence in the case. But when you put a gag order and say you can't talk at all, it's unnecessary. It leads to a lack of transparency, which is a huge part of what makes our system wonderful, and it leads to distrust, and I don't like it. So those are my thoughts on it. I don't think it was necessary here. I don't think that there is any information that's going to be coming out that somehow is going to influence the community more than we already know. There you are. Ain't no holla back, girl. Appreciate you asking the question. Very happy to answer it, and I hope that I did. Eroy, thank you so much for the super chat. So hypothetically, they could only get murder 2 in Utah and murder 1 in California. Also a very interesting question. No, it's not that they are prevented from proving the intent because the intent was formed in California. It's just that California has a nexus to the case because the intent was formed in California. In other words, I'm trying to think of a situation of where you might be able to say that Ashlee only even decided to commit the murder once she was in Utah. Then you could say, well, the entire crime from its inception to its completion was committed in another state. Therefore, what jurisdiction, what nexus does California even have to it? But hypothetically, to answer your question, Eroy, if this was prosecuted in Utah, it wouldn't present a problem. They would talk about how she devised this plan in another state and completed it here, and they're not prevented from doing that. It's just California does maintain a reason to prosecute it. I'm trying to think of a better example. I mean, it would be one thing if in the Michael McKee or in the Ashlee Buzzard case is probably still the better example. If they had moved to Utah and were there for several weeks to several months before she committed the murder, then California, you'd be like, well, wait a minute. I know you lived here before, but what connection do you have to this case anymore? Well, that's the connection that California maintains and why they extradited her back. Great questions, everybody. God, you guys are smart. Gina Gilmore, look at you. Thank you so much for the super chat. That's so generous of you. Says, when I was a teacher, we had a student who had spent time in a mental lockup for a violent assault. When he was registered at our school, all faculty was notified and a para was appointed to shadow him. Well, there you go. Very interesting. Okay, there you go. Now, I got a follow up for you, Gina, is were the parents notified? I think that's an interesting question too. I'm glad that the school was notified, and that makes a lot of sense. But I'm curious if they went as far as telling the parents as well, because I would want to know. At the same time, I understand why they wouldn't tell everybody, but I would want to know. Great stuff, you guys. Thank you so much. All right, let's keep it rolling here. Where am I? Get it together. Take a deep breath, Ritter. Everybody have a sip of coffee while I figure out what I'm doing. Hold on, hold on. Okay, here we go. Wait a minute. Okay, here we go.
Good evening, this is Helen, the Scottish Llama in Adrien, Edinburgh. I am wondering what Andrew Dykes being arrested for the murder of Tanya Jackson, perhaps better known as Peaches, can do to the prosecution of Rex Heuermann, given earlier comments by the then police commissioner in 2011 that all 10 bodies was the work of one serial killer.
HTSL from Edinburgh, Scotland. Okay, I'm not insane that was computer generated, right? With a Scottish accent. That was fantastic. I love that. But next time, HTSL, we'd love to hear from you because we love hearing your voice. But that was very clever. That caught me off guard. Thank you so much for the question. Always love hearing from you. So, and it's an excellent question. We're talking about the Rex Heuermann case, kind of. If you remember, and we did an extensive case notes on this and a case files follow-up that I would encourage all of you to listen to, where we went into this case in depth. And there's a lot of moving parts to it. He's been charged with 7 different murders. And one of the murders that they thought was connected to him, we found out has not been. And that's what's interesting about this case as well, is it's really started to open up a lot of unsolved things for people that were discovered in that same area of Gilgo Beach on Long Island. One of those was a woman and a child that had long been described only as Peaches. It was a Jane Doe female who was unidentified, but was referred to as Peaches because of a tattoo that she had of peaches. And later on, so she was murdered. There you go. There's the tattoo. She was murdered in 97. Her body was not found. Tanya, we now know her name to be Tanya Denise Jackson, was not found until 2011. Tatiana was found at Gilgo Beach some 14 years later, and genetically identified as the child of Peaches. But before all of this was done, she was just referred to as female baby Doe, 2 years old, beautiful, beautiful little girl, who, again, just a evil personified in taking the life of a mother and a 2-year-old. Who, by the way, authorities now believe that the person responsible for their death is the father of the 2-year-old. Part of the way they did that was when they identified Tatiana, her birth certificate says Tatiana Dykes. And the not all that much remarkable police work were able to then identify a man by the name of Andrew Dykes as being her father, and therefore their prime suspect, and he was arrested. Now, Helen's question is, will that or does that have any effect on the prosecution of Rex Heuermann? The short answer is no. This is not going to come up. It's not a part of the case. He's not been charged with it. Jurors will likely not hear about it. One caveat on that is that part of the defense here, if they are allowed, is they're going to try to say that some of, if not all of these murders were committed by somebody else, and that the prosecution and investigation was myopic, and they only went after this man, and they only tied it to him through DNA. But these were women who had come in contact with other men, and there was, other genetic material, and they should have followed those leads. And when you have a case where somebody whose body was located in the same area and is now been tied to another person, well, why isn't that person being looked at as being the same person tied to these other murders? They're going to try to make that argument. I don't think that they will be successful with it. They have also tried to make that argument in another set of murders that was another man has been convicted for it. Again, I think what's going to happen is the judge is going to make pretrial rulings that none of this comes into court, because it is all third-party culpability and doesn't rise to the level to allow it. So likely will not affect the prosecution at all. But great question. Helen HTSL, speaking through her computer from Edinburgh, Scotland. True crime in a minute. You are so fantastic. Love you so much. Thank you so much for all the support. And thank you for gifting the Courtroom Confidential, 20 Courtroom Confidential memberships. I love this. I think our membership has doubled in the past hour. You guys are fantastic. All right. And Blimey Hermione, thank you for the super chat, says, thank you, Josh. That makes sense. Oh, I always appreciate when I make sense. Appreciate that. All right. Let's keep it rolling here.
Hi, Josh and the CC community. Court Dog Daniel here, 97% juiced in New Britain, Connecticut. I have a question about judges and the decisions that they make. In the Tyler Robinson case, the judge is being asked to consider a motion to disqualify the entire prosecution team on conflict of interest. A big ruling that could have major appellate consequences. When a judge is facing a decision like that, is he or she allowed to consult informally with other trusted colleagues, like former law school buddies or others in the legal community, to see if the ruling that they make is likely to survive an appeal? Does that professional consultation exist in practice, and is it confidential, and where is the ethical line? Thanks again for your excellent analysis.
CDD from New Britain, Connecticut. One of my dudes in the house. Appreciate you, my friend. Great question, too. The Tyler Robinson case. This case, boy, is this one starting to bother me. This one, I'm really not getting the best vibes from this judge. I used to like this judge a lot. I thought this judge, and I'm still hopeful. I'm not going to pass judgment just yet. We're still kind of early on here. Tony Graff, right? Do I got that right? He is, first of all, he's a very experienced lawyer. He was a prosecutor for many, many, many years, and one of the supervising prosecutors. He has not been a judge for all that long. It hasn't even been a year. And why this huge, one of the hugest cases in the country, landed on his desk, I don't understand. It's a particular of Utah. I think it's all random, and his ticket happened to be up next. But originally, I thought, he's very thoughtful and deliberate in court. Most of the statements that he makes are written out ahead of time. And I thought, you know what? Good. He's a very contemplative judge. He's a very thoughtful judge. He's going to be a great judge for this. This last hearing has made me very nervous. I think that he's starting to show that he's in a little bit above his head on this case. And this defense team, I think, has smelled blood in the water, and they're going after him and trying to get as much out of this as they possibly can. And if I'm going to continue to throw blame at everyone, the prosecution is not being strong enough in pushing back on this stuff. The judge, I think, realizes it's a huge case. The entire country is watching, and it's a death penalty case. And so he's rightfully cautious. But some of this stuff is an easy call. This is an easy call. Whether or not the entire state's attorney's office should be disqualified. Here's the argument. The daughter of a supervising attorney, not even the attorneys in court, but someone in admin, that person's daughter was in attendance amongst the thousands of people that day, didn't even witness the murder, sends a text exchange with their parents saying, someone got shot. That's the first text. Someone got shot. Follows that up with, oh, it's Charlie. That they're saying that that connection should disqualify the entire state's attorney's office. Actually, that's not true. It's that that's a connection has so infiltrated. There's the text exchange. You see, the first one is someone got shot. Then they realize it's Charlie. They didn't even witness this thing. They were 85 feet away. That this connection, as tangential as it is, has so infiltrated the prosecutor's office with emotion that they cannot even decide this case. The judge should have denied this early on. But rather than doing that, the judge is entertaining a bunch of argument, entertaining a full-fledged evidentiary hearing where they're calling Jeff Gray, the DA in Utah, to the stand to testify. And before all of that, they had a big argument about whether or not the state's attorney's office should even be able to argue if there's a conflict, that they should have counsel appointed for them in the form of the AG to even argue this. It was like I was watching the wheels come off in slow motion, and I'm troubled by it. That's not entirely your question, though, Court Dog Daniel. Your question is, can this judge consult with other judges or colleagues to make sure that they get it right? The answer is yes, judges do that, and they do it often, and yes, it's allowed. First of all, this judge likely has a team of what are called research attorneys, law clerks, and past the bar attorneys who will act as research attorneys for this judge. These judges are not encyclopedias where they just know the case law on everything. They go back and they hand these questions over, the motion, to a team of research attorneys who do all the research for them. The judge makes the call and says, here's what's going to be our opinion, but might even turn to a research attorney and go, write out the opinion for me with all the case law and I'll review it. Much like the justices on the Supreme Court do. They've got a team of people working for them. Research attorneys, law clerks, everybody else. And judges will oftentimes talk to colleagues, other judges. When I was a prosecutor, there were times where we would kind of make an inside joke that if a particularly kind of nuanced issue would be asked of a judge, and that judge would go, well, I'm going to take this under advisement in chambers, that we would all joke, well, I hope Judge, and I won't say the name, but I hope Judge so-and-so is available, because we all knew they were back in chambers making a phone call to this very experienced judge in the building who knew everything, and calling that judge and going, hey, what would you do here? Now, this judge has to make the decision, and that's where it's not like judge by proxy, but they are consulting with other judges. I mean, just like attorneys do. They talk to their colleagues and go, what, have you ever dealt with this before? Is there case law on this? What would you do? What are your thoughts? And I hope that he's doing that. And I imagine that he is, being as kind of an inexperienced judge as he is, but this is way too important a case, and way too many people are watching for him to be handling it the way that he did in that last hearing. And it's not like it's too late for him to make a turnaround. And I know I am hesitant to criticize judges on this channel. I try to maintain that respect, but I'm bothered on this one. Great question though. CDD. Appreciate you asking. All right, let's keep it moving here. KMTX78, thank you for the super chat, says, I am worried he will be like Judge with delays. I am too. It's going to take too long. It's already taking too long. And it's just, I call it decision paralysis. He can't make a decision. It's like he's so afraid of making the wrong decision, he won't make a decision. Well, that's the job, buddy, when you put on the black robe. All right, let's keep it rolling here.
Hi, Josh, mods, crew, and chat. This is Jules from Waterford, Connecticut. This is a community question from the Brendan Banfield trial chat. There are some trials that involve truly horrific crimes, and therefore juries are often faced with graphic details, photos, videos, and the like that can be really upsetting and even traumatizing. We're wondering if you have any information or insights of what jurors may receive in terms of post-trial support and coping resources. Afton had mentioned that some juries do receive this, some don't. And so we're wondering a little bit more about your insights on this, any information you can provide, like does it depend on the jurisdiction and what they can provide or offer in terms of resources? Does it involve more so, regardless, the nature of the crime itself? Thanks so much. Bye.
Jules from Waterford, Connecticut. Let's put you on the map. I like this. A community question from the Courtroom Confidential live trials chat. I like that. If you guys were not aware, we have a sister channel called Courtroom Confidential Live Trials, and we, as is the name suggests, cover live trials on that channel. And we are streaming right now the Brendan Banfield trial. So if you are looking for a place to watch it, please check us out over at Courtroom Confidential Live Trials, and you'll be in the chat with all your friends here. And I'm happy to answer any question that comes out of the community, and this is one of them, and it's a good one. Do jurors ever receive post-trial support or coping resources? And you kind of answered it. It really does depend on the jurisdiction, and it depends on the resources of that jurisdiction, because it's going to come out of the county coffers, right? They're going to have to pay for someone to do this and provide these services. The other part of the answer is I don't think it's done enough. We don't realize, we call upon these people to be jurors, and we say it's your civil service and you're not going to get paid. We're going to pay you very little. And we're going to ask you to miss work, and we're going to ask you to miss time with your family. And we're going to ask you to sometimes sit through something horrific. The jury in Uvalde, I can't imagine how their lives have been changed after hearing and seeing the things that they have and being intimately a part of that process, dealing with a horrific thing like the murder of 19 children. So do they provide this to them? It depends on the county. In Los Angeles, we have a large part of the county department called Victim Services, which offers this kind of support to people testifying, to children, and it will extend some of that, I do believe, to jurors, but really not enough. I think it's something that should be explored more and something that should be talked about more. That, yeah, they should have somebody at least to talk to at least kind of help them through this process if they need to talk to someone about it, instead of just saying, hey, thank you for your jury service. You know, you're good for the next year. Expect a summons in a year or so. So great question, Jules, from Waterford. And I hope that answers that for the community. If you guys are, if some of you are in the chat today, please say hello and let everybody know to come over to Courtroom Confidential Live Trials for watching all your live trial streaming. All right, let's keep it rolling.
Hi, everybody. This is Sonia from Chicago. Happy Sunday Fun Day. I'm calling to ask about the arrest of Neo, who is David's friend, apparently. Is that related? We didn't have time to quite get into it today, so I thought I would call and ask it on the voicemail. Hope everyone's having a great day. Love you guys. Thanks, Josh.
Sonia. Love hearing from Shy Gal from Chicago, Illinois. There you are. Hope you're staying warm. Can't imagine what the temperature is like in Chicago right now. Great question. And this is one of the ones I referred to earlier that we kind of alluded to this, is what happens when somebody is under subpoena and they don't show up? Well, you're finding out. This gentleman, Neo Langston, is a friend of and connected to David, formerly known as David Anthony Burke. This is dealing with the death and likely murder of Celeste Rivas. So the latest on this case is that they have convened a grand jury, which is serving the function of investigation, meaning they are subpoenaing and putting people on the stand to gather information to, I think, even determine if they believe a murder took place here. Once they determine that, then they have to determine who's responsible for it. And so those questions are not entirely being posed to this grand jury. This grand jury is acting for the purpose of putting witness testimony on the record, putting these people under subpoena, and they may at the end pose to them an indictment, but that is not exactly why they're being convened. Kind of a little bit in the weeds here. But what happened is that this guy, Neo, was served with a subpoena. So, as I explained earlier, that means the court is not kindly asking him, the court is ordering him to show up to court. Well, what happens when you have an order and you disobey that order? They call it a failure to appear, and the judge will issue a bench warrant. So the grand jury, though there's no judge, the grand jury can manifest the power to go to a judge and ask for a warrant to be issued for his failure to appear subject to the subpoena. So he was served with a subpoena. He didn't show up. They found him in Montana. They locked him up. They brought him back to Los Angeles, and they told him, don't play games, dude. And now he's going to testify. Does this mean that a arrest is forthcoming? I don't know. I don't want to get too excited about this whole thing. I think what it's showing us more than anything is they are taking this grand jury very seriously. And it's also teaching you that Beth Silverman is not a DA to be trifled with. So show up to court. You got a subpoena. Don't play games. This is dead serious stuff. We want to get to the bottom of this. And I imagine that she will. So I hope arrests are coming soon. I can't imagine that they are not, but it does seem to be taking a while. But thank you so much, Sonia, for the wonderful question. All right, let's keep it rolling here. Don't run out of time, Ritter. People got to watch football. All right.
Hello, Josh and everyone at Courtroom Confidential. This is Deb from Arlington, Washington. First off, I wanted to say thank you to this incredibly generous and gracious community. I almost never catch live because there's other streams that I'm watching or other things going on. I just can't make it, but I will very often end up with a gifted membership. And so thank you very much, especially to whomever gifted me the one that I got a couple weeks ago. I really appreciate it. First, I wanted to ask about or say something about the Brendan Banfield trial. Josh, you mentioned that this could never be a script in Hollywood. It's happened twice. First, people have mentioned that it was an episode of The Closer, which I have not seen. But I remember this from an episode of NCIS from one of the first few seasons. I think Sasha Alexander was still in the cast. So it was one of the first few seasons of NCIS, and it's one that still gives me nightmares. I will call back with the other thing I wanted to mention because I think I'm very short on time. Talk to you in a minute. Bye.
Sounds like ET's in the back.
Again. So, in the last recording, and in this one, I'm sure you're gonna hear my cat crowing in the background. That's my space princess Tali'Zorah. If you played Mass Effect, it's that Tali'Zorah. If you know, you know. She's a happy girl and she's very vocal about it. I would apologize, but you know, she's a happy cat. I'm not gonna apologize for that. So the other case I wanted to mention was Adrien Gonzales, and my thought was, the question everybody's had is, why was he charged? And I wonder if embarrassment played some kind of role in that. You know, while 300 and something officers were standing around scratching their butts waiting for a shield to arrive, Adrien was pulling kids out of a window. And I wonder if that embarrassment, hi sweetie, if that embarrassment led to some of that decision to charge him. oh God, this guy made us look bad. Now we have to make him look bad, kind of a thing. My question for you, Josh.
Thank you so much, Deb from Arlington, Washington. I loved hearing I'm glad that you explained what that was, because I couldn't tell if it was something with the recording or if you had ET sitting in the room with you, but that does sound like a very, very happy kitty. Great question. First of all, I'd love to see the episode of The Closer or NCIS talking about that. But Adrien Gonzales, this is a great question. Why Adrien? This is in the Uvalde case. As you point out, dozens upon dozens of officers responded to this. And all of them play some role, some more significant than others, in the 77-minute delay in doing something to stop this slaughter of children. Why him? Why was he put on trial? And you suggest, Deb, that it might have been political. Is it about embarrassment? Is it trying to save face? I think maybe. I think that perhaps that played a role in some of it. I mean, it does seem as though he's a bit of a sacrificial lamb. I wonder why not supervising officers. He's not the one making the call. He's not the one giving the orders here. Why not the ones giving the orders? He's the guy at the other end of a walkie-talkie being told stand down or hang tight. Why not the guys above him who are supposed to be in command? Why aren't they on trial? If we even believe that it was criminal in their delay. So a lot of things about this that rubbed me the wrong way. I mean, one, it is an incredibly fluid situation. It's a situation that I don't care how much training you have, when you're actually in the midst of it, it's hard to understand how to proceed. It's also one of the worst tragedies we can imagine. It's also a situation where the actual shooter, there's one person who's responsible for this. That person is dead. And because that person is dead, are we trying to put that blame somewhere else? And we don't know where it can land, but it has to land somewhere else. Yes, and I know another officer has been charged. But by the way, Chief Pete Arredondo is not only the only one responsible. I also think about, part of this question is that we all assume that things would have turned out better had they behaved differently. Maybe they would have. But I pose to you the question of, what if Gonzales or some other officer had said, to heck with this. I don't care about these orders. I hear kids losing their lives in there. Who's with me? Saddle up, everybody. Lock and load. Let's go in there and do something about this. And what if in doing that, other officers lost their lives? Or it caused the shooter to do something even more horrific and take other lives? Then where would we be? So, I mean, it's kind of one of those situations where all of it is awful. I say all of this not to say that I'm not bothered by it. And 77 minutes is the number I keep on coming back to. 77 minutes is a lifetime to have been waiting to do something about this. So I get the outrage. I get the community wanting to do something. I just don't know if this was the right way to do it and if this was the right person. But great question, Deb. I appreciate you asking that, and feed that kitty. Oh, Deb. Oh, my question got cut off. Would you have prosecuted Adrien? Would you have brought charges? No. No, I would not have. Not against him. Maybe there is somebody responsible. Maybe this next officer to be put on trial, I'll feel differently about it. But I mean, listen, did it get us anything? Those jurors, those family members had to sit through this entire grueling trial, and he was acquitted. Does that get anybody anything? I don't think it was. I sometimes being a prosecutor is making a unpopular decision, but because it's the right thing. And I think maybe they should have done that here. Great question, Deb. Appreciate you. And thank you for the super chat. And I'm sorry. Yeah, you did. The recording was a little goofy somehow. It did get cut off. So appreciate you. All right. Oh boy, here we are. It's the final three. We've had a good time today, though. A lot of questions. Talked about Tyler Robinson and Andrew Dykes and Ashlee Buzzard, a bunch of stuff. We've been all over the world. You guys are fantastic. All right. Who's bringing us home here? Here's our final three. If I can just find where I'm at. Here we go. Hold on. See, too much talking, not enough button pressing.
This is Beth from Denmark. Joss, can you talk about this topic? Why do defendants rarely plead guilty? From Mike King. Profiling evil, the initial hearing is not a confession booth and not a time for moral reckoning. It is not a time to determine guilt or innocence. It is a procedural safeguard in U.S. law. At the hearing, the court formally reads the charges. They inform the defendant of their rights and remind the defendant of their constitutional protections. Defense attorneys will often advise their client to plead not guilty at that time, even in cases where the evidence is overwhelming. That is because pleading guilty too early can permanently damage the integrity of the case. It can prevent the full disclosure of evidence. It can limit mitigation. Entering pleas before trial establishes consequences before forensic evidence, expert testimony, and intent have been fully examined. A hasty guilty plea does not honor the victims. It almost always creates an appeal and problems and instability. And the more severe the potential punishment, in the case of death penalty and life imprisonment, the more cautious the court must be, as they exist to produce results that can withstand decades of scrutiny. Bye-bye.
Beth from Denmark. Let's put you on the map, first of all. This is our first Denmark call, right? I think so. I don't see any other dots there in Denmark. So first of all, let me give set off some virtual fireworks for Beth. Appreciate you calling in. And Beth, also, I appreciate you making whatever efforts you needed to make in order to make the call. And I know that this was a computer generated and maybe it was a language thing or whatever it was, but I am so grateful that you wanted to be a part of Sunday Fun Day and a part of the community. So thank you for making the call. I appreciate that. And it's a great question too. But by the way, you provided probably the best answer in your question. I think you credited that to, oh shoot, who was it? In the question, you credited that to Mike King. And I think it's an excellent answer. I can't even really improve upon that answer. He's absolutely right. So Beth's question goes back to, we always hear about a defendant got arrested and, oh, they entered a plea of not guilty. Does it ever work the other way? In my entire career, I have never seen someone enter a plea of guilty at arraignment. That's what we're talking about. Is the way it works in our system is that you are arrested and then they have a matter of days, pardon me, to get you to arraignment. An arraignment is written into the Constitution. An arraignment is a formal advisement of the charges against you and an advisement of your rights and the first opportunity for you to be handed evidence. And it's that last part, which is why we never see a plea. when you are first arrested and you get into court, far would we expect defendants to just say, yeah, I did it, before your attorney has had a chance to look at page number 1. Maybe you did do it, quote unquote, but maybe the government hasn't proven it. Or maybe the government trampled all over your constitutional rights in getting the evidence. And so it would just be a colossal miscarriage and acting foolish to enter a plea of guilty right at the beginning. It may have happened, and I'm sure it does happen, but I've never experienced it. So even if it's a short turnaround, usually people come in, plead not guilty, and then they may plead guilty, have a change of plea at the next hearing. But the idea of ever pleading guilty at day number 1, when you haven't looked at one typed page of evidence against you, is just a foolish way to begin. And I can't imagine any attorney certainly ever allowing that to happen. But it's a great question because we see it all the time and we don't ever question it. But yeah, people at their arraignment are going to plead not guilty, put it over to another date, have a chance for their attorney to take a look at the evidence. And maybe the attorney turns to them and goes, listen, dude, they've got everything on you and they're giving you a great offer. We need to take it. And that does happen quite a bit, especially in stuff like, DUIs, where there's maybe not a lot of wiggle room and argument there. And they'll plead not guilty at arraignment, bring it over to another date, plead guilty, go on with their lives. Thank you so much, Beth, from Denmark, putting Denmark on the map. I love it. All right. Moving on here. Our penultimate question.
Hello, Josh and the fabulous Courtroom Confidential team. This is Calliope from Toronto, Ontario, Canada. I have 2 questions today. One is, why are lawyers allowed to lead during cross-examination? It makes sense why they're not allowed to lead during direct. That makes sense to me, but I'm not entirely clear on why that's not the case for cross-examination. And the second question is, when you're in law school, do they teach you sort of the art of argument, like the logical thinking? I'd ask this because that's something I really wish I could learn or be better at. You see these lawyers be able to think on their feet often. Clearly, you need to know your case well, but there's something about being able to bring up a counterpoint almost instantly. And I realize some lawyers have a real flair for this and they're really good on their feet, not necessarily everyone, but still, it's sort of like that's what a lawyer does. They can really argue very well. If you know if there's an answer, I want to see if I can learn to argue that way. Anyways, thank you so much. I'm looking forward to hearing your responses. Bye.
Calliope from Toronto, Canada. Thank you so much for calling in. Good to hear from you again. Great questions as always. Let me take the second part first. Do they teach you the art of argument in law school? No, not certainly. I will say this, certainly not nearly enough. You will take some classes on motion writing, where you will be critiqued on forming arguments, right? In just the way that you lay out a motion and make an argument in a motion. You're being taught how to critically analyze. They call it IRAC, issue, rule, application, conclusion, and how you analyze every case. What is the issue at play here? What is the rule that's at play? How do you apply the rule to the issue? And what is your ultimate conclusion? So you're learning kind of a critical thinking process, but the actual idea of like rhetorics and like learning argument and how to certainly respond in a courtroom, no, not all that much. Now, many schools offer trial advocacy, which are electives that you have to take, which can sometimes be very good for that. I actually was part of a program at my law school, Loyola, called the Poles-Hobbs program. run by a woman by the name of Susan Poles, who's a fantastic professor. I think she's still there, who did a trial advocacy class that was fantastic. Our school was actually very good. They have trial advocacy teams and competitions. I didn't do that, but I did take the class, and you learn a lot about thinking on your feet and analyzing what objections to make in real time, how to respond to when those objections are made. That's a big part of being a lawyer that is not really appreciated. And the good lawyers are good at it, and the bad lawyers not so much, is when a question you ask is objected to, do you lose your notes and lose your mind and not be able to respond? Or can you roll with the punches and just correct the question, or ask another question, or move on, or get the information a better way? Those are the good lawyers, the ones that can pivot in those situations, the ones that get an objection sustained and they're looking at their notes and looking at the judge like, I don't know what to do next. They are not that great. So yeah, we have trial advocacy, but not nearly as much about just learning how to make a good argument as you would think. It's much more just about, here's a bunch of case law, remember all this stuff, have a good life. Why though? And I like this question too, because it's something I didn't think to ever answer. Why are you allowed to ask leading questions on cross-examination, but not on direct? And the reason for that is, if it's your own witness, we don't want you in the pursuit of truth and veracity. We don't want you suggesting the answer to your own witness. Your own witness who's friendly to you, that's what's considered a witness that's, on your side, or at least objectively impartial. You should not have to suggest the answer to them. And that's why leading questions are not allowed. You're just supposed to be asking open-ended questions that allow the witness their evidence, their testimony to play out naturally. Now, on cross, or even when that witness is considered hostile, you're allowed to lead. Well, why are you allowed to lead? Because now we're in the pursuit of truth. We're allowing you to control the witness a little bit more. And especially when the witness is under cross and considered not friendly to that party making the questions, we don't want them adding a bunch of information and becoming an advocate on the stand. So that's why leading questions are yes or no questions, because the attorney asking those questions is trying to make a very specific point. Isn't it true that you didn't look at the crosswalk before you started to enter the crosswalk? That you didn't look at the crosswalk sign before you started to enter? Isn't that true? If we just said, if we didn't allow for that lead, then the person could get into all the stuff about how they had a bad day and they were looking at the crosswalk and they thought, no, the answer is yes or no. And that can be cleared up on redirect, but the person on cross should be allowed to make surgical points. And if they weren't allowed to do that, you could understand what a mess the whole thing would turn into. So it's all in this idea of, one, I think, efficiency, but more importantly, the pursuit of truth, that you would allow for confined yes or no leading questions where the answer is being suggested on cross, but not on direct. And I hope that clears that up, Calliope. It's a great question, something I don't think about enough. And there you are. It says, thanks again. That makes a lot of sense regarding leading during cross. Well, I hope yeah, good job, Josh. Eroy, you are so fantastic. Thank you for your generosity. He says, shout out to the mods, Tiff, Josh, for educating us on the benefits that AI provides to some of our crew members that need the assistance to interact with all of us. I love that we get to interact with people from all around the world. I love that too. I think it's fantastic. Good on the clever end arounds that people have come up with. Appreciate that, Eroy, and appreciate everybody who's been decided to participate. The more the merrier. Would love to hear from everybody. Even down in McMurdo, what was it? The McMurdo, I think I'm butchering that name already. Yeah, the McMurdo Science Station in Antarctica. Wendy Joan, thank you so much for supporting the mods with coffees. Appreciate you, Wendy. Forrest Nelson, thank you so much for supporting the mods with coffees. All right. Handkerchiefs all around. It is our last question of the day, but we've had a lot of fun. Don't get too sad. We actually went overtime a little bit, and we've got football to watch today. Who's bringing us home? Who's our very last question of the day? Sorry about that, guys.
Hi, Josh and the CC community. This is Nettie D from Wasilla, Alaska. My question is about Jonathan Gerlach, Pennsylvania's friendly neighborhood grave robber. I know that at this point he's facing over 500 charges, including abuse of a corpse, theft, and desecration. My question is, could he be facing more charges being added, or is that unlikely with so many charges already made? And what sort of penalties could he be facing based on this vast number of charges? Thanks for your time. Bye-bye.
Nettie from Wasilla, Alaska. I love that we got a call from Alaska before we ended today. And I love, Nettie, that you made us talk about grave robbers before we ended our day. Wouldn't be a Sunday fun day without something this horrific. There he is, Jonathan Gerlach, 34 years old. Already made some interesting lifestyle changes, apparently. He is been charged with, get this, 496 counts. Why is that? Well, on January 8th of this year in Ephrata, and I hope I'm pronouncing that right, Pennsylvania, on the outskirts of Philadelphia, he was apprehended, and inside of both his home and storage locker, they found what they believe to be over 100 full or partial sets of skeletal and human remains. He had been going out with a crowbar to the Mount Moriah Cemetery, and I imagine other cemeteries, and grave robbing. Unclear at this point as to motive. I think some of the suspicion is that there's this weird black market for human remains, and that he may have been trying to make money off of that. No one is saying that he's responsible for any of these deaths, nor is it fully explained what he was doing with the remains other than storing them and perhaps selling them. And it ran the gamut. There are some remains that they believe are over 200 years old, and there are some remains that they believe are even of infants. It's really sad. It's really, really, really sad. And it's disgusting and it's bizarre. And I really feel bad for the family members who've, put their loved one to rest, and the pain of going through that, and then the pain of going through realizing that this person had desecrated their burial. So he is, like I said, looking at least 100 counts of abuse of a corpse, 100 counts of taking and receiving stolen property, and several other charges. I don't know what exposure he's looking at. I imagine it's significant prison time, though, because these things are going to add up. So really gross, really disturbing, and really sad. But thank you, Nettie, for bringing us home today. Nettie from Wasilla, Alaska. Appreciate you. All right. I'm running a little overtime, so let me get through my announcements here and get you guys out of here and on with your day. First of all, Let me tell you about the website, thecourtroomconfidential.com. It does have a "the" in the front. Thecourtroomconfidential.com is where you will find membership, messages, and merch. First of all, messages. If you thought to yourself, hey, I got a question that I would like him to answer, please go to thecourtroomconfidential.com and click on leave us a message, and I will answer those messages like you just heard at our next Sunday Fun Day. And we encourage you to do that, however you can make it possible. 2, membership. A bunch of you received memberships, a lot of gifted memberships today. Again, thank you to everybody who was so generous in your support, and to everybody who joined up. If you are curious how to do that, the best way to do it is to go to thecourtroomconfidential.com and click on become a member, and you can find out about all the perks of membership there. Thank you to Cynthian for supporting the mods with coffees. And finally, merch. We've got it all, everybody. We've got you covered in cold weather. We've got you covered in hot weather. We've got t-shirts. We've got pajama pants. We've got mugs. We've got tumblers. We've got all sorts of t-shirt colors. We've got you covered. Everything you could want. These quarter zips, I love them. I have one in gray, but these are the new colors, navy and black. I want to get probably one of each because I wear that all the time. Great stuff. Membership has its privileges, says True Crime in a Minute. Josh, Tiff, and Kaylin do incredible members only lives. We do a lot of members only live, at least one a week, certainly one a month for everybody. And a bunch of other perks that we throw in there. And we've got these kind of fun t-shirts and sweaters. We got everything. Check it out. Including this shirt that I'm wearing right now, which Kathy Mama Bear is called Perjury in Purple. Great one. Lee Hillard says it's Purple Perpetrator. I like that. That's good. Lavender Defender says Chihuahua Mama. And Jadzia Dax says plum, plea, deal, or punitive purple. Very clever, everybody. All right. What did you miss? Well, this week on Thursday, we had our weekly rap sheet from Fox Nation. We talked about the Greenberg case, Uvalde, a bunch of other stuff. That's a show that I'm very honored to be hosting alongside Paul Morrow and Donna Rotuno. That is on the streaming service Fox Nation. It's out now. Check it out. On Friday, we had our weekly roundup back here on Courtroom Confidential, where we talked about Tyler Robinson, and Banfield, and Uvalde, and Buzzard. So please check that out. It's up on our channel now. Stay tuned. Like I said, all this week, but they're taking off Monday, starting again on Tuesday at 7 a.m. Pacific, 10 a.m. Eastern, is the trial of Brendan Banfield, which we are hosting live, covering live on our sister channel, Courtroom Confidential Live Trial. So please check that out. Then tomorrow, Monday, back here on the channel, live at 5 p.m. Pacific, 8 p.m. Eastern, is our True Crime Docket. And our special guest, as I said earlier, is going to be Kathy from Gossip, Rumor, and Innuendo. So please join us. We're going to be talking about the David case and some other stuff that's taken place. And I always love chatting with Kathy because she talk about somebody who's juiced. Kathy is 100% juiced at all times. Then on Wednesday, we have another guest that I just heard we're able to announce, and that is Dr. Patrice Berry is going to be on the channel for Wednesday night live at 5 p.m. Pacific, 8 p.m. Eastern. She's fantastic. So we're going to kind of pick her beautiful brain, talking about some of the cases that are in the news and her perspective as a psychologist on those things. So you've got a jam-packed week of wonderful guests already. We would love to have you. And then finally, we've even got you covered all the way into May 29th through 31st. Courtroom Confidential, the entire crew, and all of you, we hope, are going to Vegas, baby, for CrimeCon. That is, like I said, May 29th through 31st in Vegas. And if you have not purchased your ticket yet, we've got you covered with a 10% discount if you enter the word courtroom, all in caps, all one word, at checkout. That is something, a little perk that CrimeCon gave to us to hand out to all of you. So we hope to see you all there. And that is it. Let me give a very special shout out and thank you to my friend RJ for helping us out with the phone a friend today, to our mods, Afton, Sonia, Kathy, and therapists. You know, you guys are fantastic and the best in the business. Kaylin, you are, I don't even know what to say anymore. Just an absolute treasure, and we appreciate you so much. And thank you for making everything run so smoothly. And Tiffany, you're the best thing that ever happened to me, honey. Take care, everybody. Bye-bye.